Testing 1, 2, 3. Testing 1, 2, 3. Testing 1, 2, 3. Testing.
We're actually awaiting Commissioner Barbay's attendance. He was held up in traffic, so hopefully he'll be here soon. So. All right, good morning. Welcome to the Public Service Commission's administrative meeting for May 15th, 2024. First item is the minutes from our meeting on May 8th, 2024. Commissioner Sushman.
Aye.
Commissioner Barbay. Aye. Commissioner Richard.
Aye.
Commissioner O'Donnell.
Aye.
I vote aye.
Morning, Mr. Chair. There are 4 items on today's consent agenda. Item number 1 consists of revised tariff pages from Securus Technologies LLC. Item number 2 is a notice of refinancing and change in ownership from CBTS Technology Solutions LLC. Item number 3 is a notification of upstream ownership change from Worthington Energy Consultants LLC. And item number 4 is a request for certification as a renewable energy facility from Avangrid Renewables LLC.
Okay, so is there anybody here from Securus?
Yes, Mr. Chairman. Good morning, Mr. Chairman and Commissioners.
So actually, before we go to that, so does staff have any comments they want to make on item 1?
Good morning, Mr. Chair and Commissioners. Evan Thomas on behalf of staff. On April 12th, 2024, Securus Technologies LLC filed revised tariff pages to its Maryland Public Service Commission tariff number 1. The revisions update the company's address and contact information, update the taxes and fees language in section 2.10, and remove outdated mileage language from section 4.1.1. The main change is to section 2.10, where the company is adding language around the federal cost recovery charge to state that it will collect government-imposed charges that can't be individually itemized, such as the charges for telecommunications relay service, local number portability, North American number planning or numbering plan administration, and other government-imposed charges. On Monday, OPC did file comments. I can address those after OPC. I think that'd be appropriate. But we do recommend that the Commission accept the tariff pages for filing with an effective date of May 15th, 2024.
Okay, any questions for staff? Okay, so before I turn to you, let me actually have the representative from the Office of People's Counsel who, and then you can address both what staff said and what they said, so.
Good morning, Mr. Chairman, Commissioners. Mark Shebus for the Office of People's Counsel. We submitted a comment letter on Monday opposing one part of this application, which was inclusion in the federal cost recovery fee of the local number portability charge. Now, we didn't cite in our letter the applicable law governing whether companies can approve this, and I'll read it to the Commission now. It's a federal regulation, 47 CFR 52.33, and it B, and it states, all telecommunications carriers other than incumbent local exchange carriers may recover their number portability costs in any manner consistent with applicable state and federal laws and regulations.
Anthony, how you doing? Good. Jane, I'm the chaplain for today.
The gist of that regulation is that this is the type of fee, a federal charge, that the company must pay, but that it is not required to recover from its customers. It may, subject to federal and state law. Our argument is that the Commission should not approve inclusion of this particular charge because it doesn't benefit the customers of the company. Now, if you read the tariff, technically the customer is the correctional institutions that the customer serves, and the individuals incarcerated who take advantage of the services and their loved ones are end users. But the point is that none of those people benefit through this charge, and the company has not traditionally, up to this point, recovered it from these transactions. Nor has the company in its letter provided any reason why it should. Now, you can argue that it doesn't make sense for the company, given its business model. It's not a traditional carrier. It provides calling services to correctional institutions under contracts with them. It may not make sense for them to be subject to this fee in the first place, but it is a condition of serving as a telecommunications carrier under federal law. When they sought their application from the FCC, they agreed to this condition and to the risk that they might not be able to recover it from their customers. And as between two groups, on the one hand the company, and on the other hand incarcerated individuals and their friends and family whom they communicate with, as between those two groups as to on whom this cost should fall, we think that in the absence of some good explanation from the company, which is not provided in their letter, it should continue to fall with the company, which is where it has been so far. That is what the public interest in Maryland requires, and therefore what supervision and regulation of this company requires in the public interest. And I'm happy to answer any questions.
Any questions for OPC? All right, so now let's turn to the company, and why don't you respond to both staff and OPC? Anything else
Good
you want
morning,
to add?
Mr. Chairman and Commissioners. My name is Paul Bezzosi. I'm an attorney with Squire Patton Boggs in Washington, D.C. Here today on behalf of Securus Technologies, LLC, which, as the Office of People's Counsel says, provides incarcerated people's calling services in Maryland pursuant to tariff approved by the Commission. Let me address directly the issue of benefit and benefit to the incarcerated person, who is the person that is making these calls to friends and family, and friends and family. There's certainly a benefit to the friends and family in terms of local number portability. They have the telephone number. If they want to change their telephone number, landline, wireless, this is a fund that supports their ability to do that. And those are the people who are primarily paying for these calls through deposits they make in accounts that are drawn down by the incarcerated person when they make the call. There's also a benefit theoretically to the incarcerated person, because if the number is changed, then the incarcerated person has to get permission to add that number to an approved list at the correctional facility, and this may delay the time and ability of the incarcerated person to make calls if there were no local number portability fund to support it. So that is the company's point on the benefit argument. I think it was conceded that this is a mandatory federal charge. The federal law allows the company to pass this through to its end user customers in the call rates. This is not an element of the call rate. The call rates, the permitted call rates, are capped under FCC rules, and this will not affect the call rate in any way. Those will remain capped. The impact, according to the customer's estimate, of adding these two additional federal mandatory charges to the federal cost recovery charge in their tariff is about a penny on a 11.5 minute average call. And if you focus only on the local number portability aspect of it, depending upon how the percentages are calculated, it could be even less than that. So I think the company's position is it's allowed to do this under federal law. There's no impact on the call rate here. They remain capped, and that the tariff should be approved as recommended by the staff.
Okay, any questions for the company? So, why don't you?
Yeah, thank you. In terms of the benefits of local number portability, I think we agree with what the company stated, but we just want to add one comment to that. The local number portability cost, in a way, can provide a larger social benefit as well, and we believe that the people in the correctional facilities should contribute toward the social benefit. So the LMP cost supports something called the Number Portability Action Center, which is this database, which is basically the underlying database that manages or has all of the ported numbers and the routes between them. And this database is utilized by law enforcement in investigations in identifying which carrier is aligned with a telephone number and vice versa. And so we believe that since that is funded through this LMP cost, there is this greater social benefit, and it makes sense for the people in the correctional facilities to contribute this cost as well. And so that would be, though, in addition to the benefits pointed out by the company.
Sure, yeah. Actually, I was going to turn back to you, and then I'll come back to the company. So.
Thank you. We fully agree that the local number portability program provides general benefits. I think anybody who has switched from one, like wireless carrier, to another, Verizon to T-Mobile, whatever, you're able to take your number with you. and that's a really good benefit. If you change an address, you're able to take your landline phone number with you from one address to another. We don't dispute that this is a good program and should be funded, and that people should generally contribute to it. On the question of the benefits to the friends and family that the company raised and the benefits to the incarcerated individuals, with respect to friends and family, of course, the local number portability program will benefit them. But each of them, if that person has a phone number, is subject to paying this fee through their own carrier. Now, we don't know whether their carriers are actually recovering their fee. It's a competitive marketplace. Some of them may be recovering it, some of them may not be, in order to have a greater advantage in that marketplace. With respect to the benefits to, whatever benefit the local number portability program has to those individuals is realized through the fees that they are paying, if at all, through their own carriers. With respect to the incarcerated individuals, I think the argument is that maintenance of the phone numbers of the friends and family will benefit them, because if one of those persons loses their phone number, there's an administrative burden associated with it, that new number being added to the Securus list for calling. And we don't deny that there is a little bit of burden involved, but I think it's de minimis compared to the ongoing cost that this charge, the inclusion of this charge, will have in these calls between incarcerated individuals and their loved ones. Thank you.
So, question for staff. This is not the only company that provides inmate calling, right?
That's correct.
So what is related to this local number portability charge, what did the other companies that offer this service do when it comes to that?
So I'm not 100% sure in that it's not spelled out in their tariffs, so I would believe that it is, I guess, paid by the companies as it currently is under Securus' tariff. That's my understanding.
Okay, so any questions for Commissioner Richard?
Maybe OPC, if you maybe you can help me understand how the cap works. It was my understanding that there are already protections for in the inmate calling system with this cap. So I thought that would ultimately, restrict, I guess, the types of, charges, costs, and everything. So maybe I'm just not understanding how the cap works and why that's not sufficient in the eyes of OPC to provide that protection.
Thank you for the question, Commissioner. I think this goes to the distinction between rate and charges that the company's counsel was drawing. I mean, technically, you might say that this charge is not part of the rate. The rates per se are capped, but whatever costs through the federal charges are recovered by the company are in addition to the rate. And they are not capped except by the actions of this commission to permit them or not permit them. Right now, the company has not been recovering this particular charge from its customers. Again, as company said, most of the charges for these calls are being paid by the friends and family of the incarcerated individuals. To date, though, it has not been recovering this particular charge. Company has not provided any explanation for why it needs to recover the charge now. There's no argument that the company is in financial straits, that there's some kind of hardship that means it should shift responsibility from itself to the incarcerated individuals and their friends and family. And we think that the public interest, people who are incarcerated and their families, I think, are disproportionately low-income individuals. And this is a population of incarcerated individuals who cannot shop. They take phone service through whatever company has contracted with the correctional institution. So they're not in a competitive marketplace. They have no choice. Their only protection is the commission in reviewing proposals like this. We think as between the two parties, it's better for the company to bear this charge than it is for incarcerated individuals and their families. That it's more in the public interest.
Okay. So despite the cap, this would in fact increase the cost to the inmate and the family.
Correct. If this charge is now included in the costs of the calls, the costs will go up. It's not going to be much, as company counsel said, but over time it adds up. And again, these are low-income individuals, and every little bit matters.
Okay, thank you.
Commissioner Sushman.
I actually have a question for company's counsel. So this charge has been in place for how long? I guess sort of going back, your contract with the facility has been in place for how long, your client's contract?
I don't know the answer to that, but Securus has been providing this service in Maryland for some period of time under its tariff. It may not be providing service now to the same correctional facilities that it has in the past. Each facility generally has a separate contract.
Okay, and is it your understanding that, at least in terms of this correctional facility, the charge has not been included in the cost of the call up until now?
That's correct. This is the tariff would permit, as part of the federal charge fee that previously had been approved in an earlier tariff for the TRS fund, to collect for both the North American Numbering Plan Administration charges and the local number portability charges.
Okay, so
And Office of People's Counsel has no objection apparently to the local number.
no, I appreciate that. I'm mostly trying to understand whether you're here today because of a change in federal policy, a change in company policy. So this is a charge that the company has paid up until now, and then a decision has been made to pass that on to the caller. Is that what's going on?
That's my understanding, as it is permitted to do under under federal law and under the FCC's regulations. I think there has to be a distinction, again, drawn here between the call rate, the per minute call rate, which is capped under the FCC's rules, and these mandatory taxes and fees and authorized fees, which the commission itself has recognized are separate and apart from the call rate, and has, under federal law, permitted that they be passed on. It's not mandated that they be passed on, but has been permitted that they be passed on. And the company is only exercising its right to do so with a minimal impact. I think a penny a call for an average call of 11.5 minutes by including these costs now in the federal cost recovery charge.
Okay, and your client provides this service to other correctional facilities?
Yes, it does, and my understanding is it has been making these tariff changes in other states where there are tariff requirements applied to them. It's been filing similar tariff changes. I don't know the status of those, but my understanding is this is not something that's specifically focused on Maryland.
Okay, so this reflects a policy change within the company.
Policy change in the company.
Okay, thank you. That's all I have.
So, some questions, I guess, either for the company or staff. So, the party that contracts with your company is institutions under the Department of Public Corrections and Safety.
That's correct.
Okay. And, I mean, do they put out an RFP and you bid on this? I mean, how do you make the contractual arrangement with the institution?
Generally, the Department of Corrections or the individual county facility will put out an RFP for competitive bidding purposes that will allow various providers of these incarcerated people's calling services to bid to provide the services. And of course, the services are provided by the correctional facility to the incarcerated people and their friends and family. And accounts are set up, funded in most cases by the friends and family, that allow the incarcerated people to make these calls. There's also certain situations where the incarcerated person himself or herself could have a debit type account set up that it would control.
And so, did this issue come up in your negotiations with the corrections department, regarding the collection of this fee? Or are they oblivious to it?
I can't give you any firsthand information on that. I'm not aware in this situation where there's been any objections by the correctional facility customers to these tariff changes.
And you talked a little bit about the fact that this is de minimis, I guess, in your view, which raises the issue of if it is, not that much money on the calls, why is the company now deciding that they want to shift the burden onto the customer, so to speak, as opposed to just eating it
Wow.
as they have in the past?
I haven't talked to the company about its business decision-making here, but I assume it is as a result of increased costs or other reasons that warrant or justify its now passing on to the customers this modest additional component of the federal cost recovery charge that it's allowed to under federal law to do.
Mr. Schlesman.
Okay, so I'm going to follow up on a question from the chair, because I am a little. I mean, I understand de minimis, but de minimis is a relative term, and my de minimis is going to be very different than somebody else's de minimis. I'm assuming when your client went in to negotiate the arrangement with the correctional facility, there was a conversation about costs, because certainly the correctional facility would not want to engage in a relationship with a carrier that's going to charge pretty outrageous costs. And so I can't help but think that part of the negotiation was understanding what the total charge would be, not just the rate. And I would like to get some information on the contractual relationship that your client has with the facility, specifically the length of the contract. I mean, this feels a little. It's in a different context, but it feels a little like slamming, and I'm a little concerned about that, where you come in, where the correctional facility makes an assumption about what's going to be charged, and whether it's de minimis or not, it wasn't part of the initial negotiation. So I would be actually very interested in knowing what the contractual relationship is and the length of the contract.
The contracts, in my experience, are usually 3 to 5 years. Remember that the correctional facility is
but
not
that may be your experience, but that doesn't answer the question about what's the length of this contract. So that, I don't know that you can answer that question, so maybe this is information that you will need to provide to the commission.
happy to provide that information to the commission. This tariff, of course, would apply to the various contracts that they have with correctional facilities in Maryland. I don't know exactly how many they have, but it's more than one. It's not just dealing with one contract. And remember, the nature of the relationship here is the correctional facility is not paying anything to Securus. The correctional facility is allowing the Securus to come in and provide this service to its population and the friends and family that they call.
Oh, I understand that, but the correctional facility is not going to agree to the contractual relationship if you're going to charge $500 for every call that's made.
Well,
So all I'm saying to you is that I'd like to actually have a better sense of what's in the relationship and what was the understanding in bringing your client aboard. I mean, to the extent that the correctional facilities assumed that the call would be capped at the rate, I'd like to know that.
well, the correctional facility, of course, the rates would be capped. The call rates would be capped under the restrictions imposed by the FCC. Your question seems to be, did the contract provide for any restrictions or cap on what charges the provider, Securus, could pass on as part of its federal cost recovery charge? Is that your question, Commissioner?
That would be one element of, yes. So would the contract provide that information?
I don't know. It would depend on the particular contract. We'd have to look at the contracts and see if there's anything in there. My guess is that there would not be a restriction in the contract in terms of passing on these charges, but I don't know the answer.
Right, and your guess is not going to answer our question, or at least my question.
Understand.
So I'd like to see the contract.
Commissioner Barve.
Thank you, Mr. Chairman. Two questions. So I presume that this local number portability charge is charged to Securus by the FCC, I suppose? Is that the...
There's a local number portability administrator that Securus gets invoiced for this charge. I think a couple of times a year to pay it.
Okay. And People's Counsel makes the argument that this service, this fee, doesn't benefit the friends and family of the inmates because they already have local number portability through their own personal plans. Would you care to respond or comment to that?
Well, this is a different carrier service that is being provided in the special situation of incarcerated people's calling service. What they pay, I don't know what they might pay to their landline carrier if they have a landline carrier or wireless carrier for other services that they might obtain. But again, I would just reemphasize that the FCC has said this is a special fee or tax that can be passed on as over and above the capped call rate, the per minute call rate. This is does not affect the call rate in any way.
So, and just to reemphasize, the caps don't really apply to this charge, correct?
The FCC has not imposed a cap on these charges because they're set periodically by these third-party administrators like the TRS Fund Administrator, the North American Numbering Plan Administrator, and the administrator of this fund for local number portability.
Thank you, Mr. Chairman.
So as a follow-up to Commissioner Suchman's questions regarding the contract, I guess one of the things I'm concerned about is, what the correctional institution is looking for when they make the contract with you. And if they're not paying this, my concern is that maybe they don't really care. And, is there anybody that sort of speaks for the inmates, or is it assumed that the correctional institution is handling it for them and just all they want to do is provide this service, and don't really care about the details?
Well, the contracts are negotiated with each of the correctional facilities. There are certain components of it relating to the services that have to be provided, and what elements there are, security for them, et cetera. The tariffing arrangements and rates also can be a subject of negotiation. But again, as I said, those are capped now under the federal rules at certain per minute charges.
Okay, so question for staff. I take it you've not really had any conversations with the Department of Corrections or any of these correctional facilities regarding these arrangements, correct?
We have not, no.
Well, I think as a start, along the lines of what Commissioner Suchman said, I think we want to actually take a look at the contract. And for staff, I actually would like you, once we get a copy of this contract, to discuss with the correctional institution the subject of this contract, sort of what their views are and how they made this arrangement and what they think about these things, if they thought about it at all.
Okay.
So with that, I'm going to move that we defer consideration of the tariff revisions filed by Securus Technologies for 2 weeks. I mean, how long can you?
Well, I just want to make it clear, if there are 5 different contracts in the state of Maryland relating to different facilities, is the commission asking to see all the contracts?
Sure, and my response to that would be, if you're seeking to pass this charge on in all 5 contracts, then yeah, I guess I do want to see all 5 of them.
And the interest is whether or not there's any restrictions in those contracts
You're right.
as to passing on this charge.
That's it. Yeah.
I'd also be interested too when you come back in a couple weeks to understand why we're doing this mid-contract, and it's not something that is part of the initial negotiation of the contract, or this is a competitive entity. You have Securus has competitors, and I'd be interested to know what they do in their contracts, because again, and part of what bothers me is again the mid-contract aspect of this change that you're requesting.
Yeah, I doubt we would have access to our competitors.
No, I understand that.
Contracts.
So, but we'll start with you, and then we'll see where this goes. So.
But just let me respond to the commissioner's last issue regarding mid-contract. This is, unless it's specifically dealt with in the contract, a modification to the tariff like this would not be something that would be subject to negotiation. And my expectation is that this is not an issue that is going to be specifically addressed in the contract, or if it's addressed, it may say that Securus can do this in accordance with the federal requirements. But let's see the contracts.
And I guess that gets me back to what having staff talk to the Department of Corrections or Correctional Institute, whoever the contracting party is on that end, to find out sort of what their view are, what's their view when they establish these contracts, and how do they go about making that decision. So we'll defer this for 2 weeks. If you get stuff to us sooner, we may try and schedule.
My understanding is the concern here is with the local number portability charge. 'Cause
Yeah.
that's the only objection that's been
Yeah,
made.
and that's the concern that was raised by OPC and like shared by us. So.
Okay. Thank you, Mr. Chairman and Commissioners.
All right, so regarding item 2, I move that we note the transfer of indirect control of CBTS Technology Solutions LLC to CBTS Borrower LLC, and the participation by CBTS Technology Solutions LLC in the new financing. Commissioner Sushman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
Commissioner O'Donnell. I vote aye. Regarding item 3, I move that we note the filing of Worthington Energy Consultants LLC. Commissioner Sushman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
Commissioner O'Donnell. I vote aye. Regarding item 4, I move that we approve the application and issue a renewable energy facilities ID certification number. Direct the applicant to establish a REC account with PJM GATS within 30 days of certification, and direct the applicant to notify the commission within 30 days if any of the information on which the application is based has changed. Commissioner Sushman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
Commissioner O'Donnell.
Aye.
I vote aye.
Mr. Chair, item number 5 on today's agenda on the administrative portion is a request from Baltimore Gas and Electric Company for an extension in the electric vehicle charger ownership.
Good morning, Mr. Chair and Commissioners. Anson Justy on behalf of staff. On April 2nd, 2024, Baltimore Gas and Electric Company, BGE, submitted a request for approval to continue owning and operating 9 EV chargers to 2030. Utility companies are currently authorized to own and operate their EV public charging stations through 2025. In collaboration with the Maryland Department of Transportation, MDOT, BGE has been awarded $1.4 million of federal funding to replace non-functioning EV charging stations through the EV Charger Reliability and Accessibility Accelerator Grant, which is part of the National Electric Vehicle Infrastructure Program, NEVI. The grant reimburses recipients for 80% of the cost to replace non-operational chargers. The remaining 20% is a cost match from ratepayers and BGE, which is estimated at approximately $280,000 of previously approved EV program budget. There are 6 charging station locations that are currently eligible for federal funding support under this grant. 6 stations will be replaced across all 6 locations, with 3 additional ones built at BGE's existing Aberdeen location. to bring that station into compliance with grant requirements for simultaneous charge capability when located along an alternative fuel corridor. This grant also requires recipients to commit to at least 5 years of maintenance from the initial date of operation for charging stations that benefit from the funding, prompting this filing. Assuming all funding is dispersed on the current timeline, BGE anticipates replacement chargers to be installed by mid-year 2025. Staff agrees with OPC's recommendation in its comments to make clear that the 3 new chargers are within the already approved 500 charger allocation. Staff recommends the Commission extend BGE's authorization to own and operate the 9 EV chargers to be replaced at the charging stations listed in Appendix A of the company's filing through 2030. Thank you.
So, any questions for staff? Commissioner Sushman.
Just very, very quickly. So the 9 chargers are going to be included in the 500 that were authorized, even though those are going to be funded mostly by federal funds.
That's correct.
Okay.
That's our position.
Okay, thank you.
Commissioner Richard.
Just so you can help me understand the MDOT NEVI network. When we say it's being transferred, these are being transferred into that network. What role does the utility then continue to play with these? And are there other, utility chargers in the NEVI MDOT network?
Right, so I saw those comments in the OPC comments and was also a little confused on that. So I would ask OPC to comment on that.
Okay, thank you.
Okay, so Office of People's Counsel.
Thank you, Mr. Chairman, Commissioners. Mark Shebist, Office of People's Counsel. When we say NEVI network, it's not as though MDOT, well, and first I should point out there is somebody from MDOT present today who can probably speak to any particular MDOT issues in much more detail than I can. But when we went by NEVI network is not an MDOT operated network. We're speaking of the network that MDOT is supporting via federal money to enhance charging infrastructure in Maryland. Most of that money will flow through these formula funds that MDOT will be getting. I think maybe it's already gotten a certain tranche of that funding and distributing to charging companies to build charging stations, first along these alternative fuel corridors that are federally recognized, and then when those corridors are fully built out in other places. So when we say NEVI network, we just mean that this is a grant that MDOT has secured. These 3 new stations in particular at Ripken Stadium are close enough to an alternative fuel corridor that they will help MDOT achieve its build-out of the AFCs, after which it can turn to, supporting charger build-outs in communities in other areas. And the other 6 stations are less part of the AFC network. There's no reason that, as far as we know, they are not along AFCs, but MDOT has recognized that those charging stations will provide value if they continue to be supported through 2030. And briefly, with respect to OPC's position generally, OPC does not oppose this request by BGE. We have the hearing coming up tomorrow in the EV pilot program, and we'll talk at length, I'm sure, about the utilities' public charger programs. In short, OPC thinks those have not been successful. Utilization rates have been low. So we don't think that utilities should be building new chargers going forward generally. And our understanding is they don't plan to after the conclusion of the current pilot. And we think there should be a conversation about transitioning away from utility-owned charging stations. But we see this as an exceptional circumstance because of MDOT's designation, MDOT's securing of this federal money, the fact that these stations will support MDOT's NEVI build-out, and it'll allow the other NEVI formula funds to go further to support other stations. Happy to answer any questions.
So, any questions for Commissioner Sushman?
Good morning, Mr. Shebus. My understanding is that you would like these 9 charging stations to not be calculated within the 500, so that you want the 500, so that it'll be 509.
That's we want the limit to remain 500, and we want these 9 charging stations to count toward those 500 stations.
Oh, you do want them?
We do.
Okay, I was confused. Okay, thank you.
Any other questions? So, actually, before I turn to the company, is there somebody here from Maryland Department of Transportation? Yes. Okay, why don't you, if you want to supplement some of the comments made by either staff or OPC, and I mean, I have some familiarity with the NEVI grant process, but you may want to elaborate on that too. So,
I don't know if I can move. All right.
okay.
Can hear me okay? Okay.
Yes.
Hi. Good morning, Commissioners. I'm Amanda Hinn representing MDOT today. I manage the NEVI program on behalf of MDOT. So to respond to staff or your questions about how these 9 charging stations would fit within the NEVI network. So currently, to provide context, MDOT's in the middle of our round 1 solicitation using formula funds. So this is where we will then use those funds to build out corridor charging. Now, the 873 Long Drive Aberdeen location mentioned that will meet compliance with counting towards one of those charging stations. That will, as OPC said, be one less charging site that we would have to build using our formula funds. Now, the other ones, the other level 2 and DC fast charging stations that are not within that 1 mile of our alternate fuel corridors, those would still contribute to what we are considering our NEVI network. To date, because we're in the middle of just round 1, there is no existing NEVI network, but it is part of the next few years of charging build out in the state. Does that answer your question?
Okay. Actually, a question for staff. Since we are having the hearing tomorrow on the EV program writ large, why are we carving this out today as opposed to dealing with this tomorrow?
I think if the commission wants to do that, it could. We got the filing. We did our research into it. I believe there's also a desire to have the funds dispersed like mid-year this year, contributing to that BG expectation that the charters go into effect mid-year next year. So that's also part of it.
Okay. Actually, sure.
Good morning, Mr. Chair and Commissioners. Drew McAuliffe on behalf of staff. And the hearing tomorrow really is more for the kind of the look back as I'm considering it. So if we were to defer it, we'd really have to defer it to that second hearing where we're kind of figuring out what to do going forward, phase 2. And also because it fits under the 500 cap, we don't see as much of a we don't consider this an expansion at all of BGs. This is just really to fix broken chargers with funds that are outside the company. So we think it's kind of a win-win.
All right, that makes sense. So let me turn to the company and any comments you want to make on any aspects of this.
Good morning, Commissioners. Joel Michelle on behalf of BGE. I also have with me Elena Janaski and Amanda Janaski and Elena Martinez Hart from our EV Smart program. Very briefly, we thank staff for its support and analysis of our filing. With respect to OPC's condition that the 9 chargers be included as part of the 500, the company has no objections to that, and that is the company's intent. And then lastly, Chair Hoover, with respect to the thought that this be deferred tomorrow, we agree with staff's position. I would encourage the commission to view this filing as simply a way that BG is trying to fulfill its current commitment and obligations to provide reliable charging. And the company took seriously the commission's recommendation that utilities work hard to find alternative fundings to do maintenance and repairs to the public charging network, and this is precisely what is intended by this current filing.
Okay. Any questions for Commissioner Schlesman?
Good morning, Ms. Michelle. So I'm looking at OPC's filing from 2 days ago, and they speak to the utilization rate of 1%. Do you have any comments on that? That seems kind of low. It's very hard to get lower than 1%. So, can you speak to whether you agree with the number, and also, I mean, separate and apart from that, can you just sort of speak to the challenges that BGE has been having in utilization of the charging stations.
Thanks for the question, Commissioner. So that is certainly something that I think will be discussed at length in Thursday's proceeding.
Okay.
But what I'll briefly offer today is that we have to keep in mind the purpose of having utilities partake in the public charging market. The intent, as I understood it, back in 2019, was to have utilities focus on areas where the private market would not necessarily be interested or rushing to offer public charging. So I don't think it should be any surprise that generally the utilization rates for public charging owned and operated by the utilities are low. In a sense, I think we went into this knowing that because of the limitations placed by the commission on where we could locate these chargers, namely properties owned, leased, or under the control of government agencies, I think there shouldn't be a great surprise that utilization rates are lower than maybe other locations. I don't offer that explanation as a complete explanation for why the utilization rate is low, but I think that's worth the commission's consideration.
Okay, and factors like sort of hardware issues or software issues, does that play into the low? And actually, this is really not a gotcha question, because we're going to talk about this more tomorrow. I mean, some of the questions really are about how do we make it better? So sort of recognizing what the challenges are, and the low utilization rate. How do we make it so that the utilization rate goes up? And how do we address, to the extent that some of the things we can't do anything about, but if there are sort of software or hardware issues, that's something that we should know about.
Yeah, absolutely, Commissioner. And I think you are on the right track that there are issues with outdated software, outdated chargers. In fact, the chargers we're looking to replace are sort of the probably oldest chargers out there in terms of make and manufacturing, and also whether or not current updated software can support those chargers. That's precisely what we're trying to address here.
Okay. All right. That's all I have. Thank you.
Commissioner Richard.
Just to pick up where Commissioner Suchman left off, I guess a concern I have is, if we continue, is the utility committed to a better performance in keeping these chargers functioning? Because reading some of the other, ratepayers, the other filings, they have a real concern with BGE specifically and their ability to operate these chargers. So, I mean, it's great to get the federal money, but are we throwing good money after bad if we're going to continue to have these same, I guess, maintenance issues, the same operation issues with these chargers?
Yes, Commissioner, thanks for the question. And absolutely, the company is committed to improving the reliability of those chargers. And that's precisely, what I found to be the irony in the comments that you referred to, Commissioner Richard, is that those comments highlighted issues with reliability, and this filing is meant to help address that precise issue, is to make our public charging network more reliable and NEVI compliant.
Okay. Well, when we started this, and we're going to have a chance on Thursday to talk about how the program has functioned, how it's performed, uptime, the reliability of these chargers was something that the company, I felt, had committed to. And we're looking at some very dismal performance metrics here. So again, I'm largely, if OPC is behind this, I will, as the ratepayer advocate, support. But again, I have some real concerns about continuing, putting ratepayer money, albeit with some support of federal money, behind this, if we're going to continue to see these types of poor performance. I mean, it's great to have these chargers in areas that may not have them, but if they don't work, then what's the point?
Yeah, understood. And I would add that this filing doesn't seek additional ratepayer funding, right? The plan here in terms of the 20% cost sharing that the company would be responsible for would be taken from current EV smart budget. Now, obviously that is ratepayer funding, but it's to be clear, we're not seeking additional ratepayer funding. And then I'll also mention that whether or not we get this funding, I am 100% confident that this commission is going to hold the company to certain reliability standards for those chargers. And so money will have to be spent to get those chargers to meet the commission standard and the company standard of reliability.
Yeah.
Here, this is just an opportunity for us to get the support of federal funds to do that.
Yeah, understood. And that's, I guess, part of the reason for tomorrow's hearing is to again look at how the company has performed and the prudency and, again, the ongoing support by ratepayers of these machines that if they don't function, we'll have to talk about amortization and all those types of things, but that'll be for tomorrow. But thank you, Mr. Chair.
So, you have a question? Or?
Yes.
Barbie, so.
Yeah, so one of the locations is the Ripken Stadium.
Correct.
Right? And you're arguing that the 1% usage rate is primarily due to the isolation of a stadium?
No, Commissioner. I'm sorry if I misspoke and led you to believe that that was the justification for the 1% utilization rate. I simply wanted to mention that certainly has to be considered as a factor generally, not in respect to this particular location.
Okay, thank you.
All right, with that, I move that we authorize the company to own and operate the 9 EV charging stations to be replaced at the charging stations listed in Appendix A of the company's filing dated April 2nd, 2024 through 2030. Commissioner Suchman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
Commissioner O'Donnell.
Aye.
I vote aye.
Mr. Chair, item number 6 is the annual STRIDE report from Columbia Gas of Maryland, Inc.
Michael, Chair, Commissioners, Michael Dean on behalf of staff. This item is the annual filing and reconciliation filing of Columbia Gas of its Strategic Infrastructure Development and Enhancement Program. The filing contains descriptions of the work done over the past year and calculations of new surcharges. The company does not currently have an approved plan for the coming year, so the surcharges are not going into effect. Staff recommends that the commission note the filing.
Okay, any questions for staff? And I take it you're from the company?
That's correct. Good morning, Chairman and Commissioners. Ken Fillion, Principal Engineer on behalf of Columbia Gas. I would like to provide a very brief update on the 3 projects that were carried over from last year's roster to complete our 8-mile commitment. 2 of the projects are currently in progress, and the 3rd project is to start in June. All work is expected to be complete this year. With that, I'm available for any further
So,
questions.
just for the record, why don't you tell me what the 3 projects are?
Gorman, 4th,
Okay.
4th Street, and what's known as the Bean property.
Okay.
Gorman and 4th are in progress, and the Bean property is to start in June.
Okay. All right. Any questions for the company? All right, I move that we note the filing. Commissioner Suchman.
Aye.
Commissioner Barbe.
Aye.
Commissioner Richard.
Aye.
Commissioner O'Donnell.
Aye.
I vote aye.
And item number 7 is a request from CPV Backbone Solar LLC to amend its CPCN.
Good morning, Mr. Chair, Commissioners. I'm Roy Terere on behalf of staff. On March 14th, 2024, CPV Backbone Solar, Backbone, or the company, asked the Commission to amend the Certificate of Public Convenience and Necessity, or CPCN, the Commission issued in connection with the Backbone, the CVP Backbone project, which is a 175 megawatt solar project. One of the licensing conditions proposed by the Maryland Power Plant Research Program, or PPRP, and adopted by the Commission is states that the project shall be constructed in a single-axis tracking solar photovoltaic system within a limit of disturbance and approximate dimensions that includes total acreage and height as described in the application or as included in the CPCN, and that any modification to the project specification must be submitted to the Commission as a request for modification of the CPCN. Backbone requests that the Commission authorize the company to use a reserve area, which is an area near the project site, with a limit of disturbance of approximately 1,450 acres, in order to increase the project's output to the originally approved capacity of 175 megawatts. According to Backbone, the original land area available for the project was reduced because of additional stormwater and erosion control management measures required by Garrett County and the Maryland Department of the Environment, which in turn reduced the project's capacity from 175 megawatts to 142.6 megawatts. Backbone stated that it has engaged both PPRP and the county, and that the county is supportive of the proposed amendment. Staff also notes that because the project's capacity will remain 175 megawatts, and the generation from the reserve area and the original project site will interconnect to the same previously identified point of interconnection, there is no need to revise the feasibility system impact facility study previously conducted in connection with the project to interconnect the project to the PJM grid. There's also no need to revise the interconnection agreements that the company executed with Potomac Edison. Backbone expects that revised PPRP conditions may require an amendment to the decommissioning plan, which the company intends to comply with. Staff recommends that the Commission grant Backbone's request by modifying the CPCN issued for the project to authorize the use of the reserve area, as shown in the Supplemental Environmental Review document, subject to any revised or additional conditions proposed by PPRP. Thank you, and I'm available for any questions.
Any questions for staff? So before I turn to the applicant, so PPRP is on board with all this?
Good morning, Chair Hoover and Commissioners. Steve Tolson, Counsel for the Power Plant Research Program, and with me is Mr. Christopher Adland, who is the project manager for this. Yes, we are in agreement with this. On May 6th of this year, we filed a letter on behalf, or a letter by PPRP containing a number of attachments to update the filing for the use of the reserve area, and there are both clean and redlined recommended modifications to the licensing conditions that were approved in the original CPCN. If incorporated now with approval today, we believe that the project that will be built in full compliance with all of the required environmental safety and engineering principles. And if you have any questions, I believe Mr. Adlin will be able to give you a much more coherent answer.
Okay. So any questions for PPRP? All right, so let me turn to the applicant.
Thank you, Chair Hoover, Commissioners. David Bugelmans on behalf of CPV Backbone Solar LLC. I'm also joined this morning by Ms. Felicia Bellows, the Senior Vice President for Renewable Development at Competitive Power Ventures, the owner and developer of this project. We have nothing to add to staff and PPRP's presentations. I will note that we have been working with PPRP on this request since October of last year. We provided a draft of the ERD addendum that's before you to PPRP. PPRP had substantial discovery for us. We had a site visit both with representatives of the state and the county to walk both the current site, which is under construction, and the reserve area. This has been a very constructive process. We've reviewed PPRP's conditions. We do not object to them. So no contested issues here. We appreciate your consideration. Again, we're here to answer any questions you may have about this request or the status of the project overall. Thank you very much.
So, any questions for the applicant? So, this is in Garrett County. Is this an abandoned coal mine site?
It is, Your Honor. It's an abandoned mountaintop removal coal mine.
I see. Okay. All right. With that, I move that we grant CPV Backbone Solar LLC's request to modify the CPCN issued for the CPV Backbone Solar Project to authorize the use of the reserve area as shown in the supplemental environmental review document, subject to any revised or additional conditions proposed by the Power Plant Research Program. Commissioner Sussman.
Aye.
Commissioner Barve.
Aye.
Commissioner Richard.
Aye.
Commissioner O'Donnell.
Aye.
I vote aye. And with that, the administrative meeting is adjourned. For those of you here for the rulemaking, we'll start that at 11:30. So.